All rise. We will obey. The International Criminal Court is now in session. L'audience la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please call the case.
Thank you, Mr. President. Situation in the Republic of Kenya in the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, ICC 01090111. And we're in open session, Your Honours.
Thank you. Appearances.
Morning, Mr. President, Your Honours. Prosecution, the appearances are the same as on the last occasion, on Tuesday, with the exception of our case manager, Ms. Grace Go, who will join us during the course of the morning.
Good morning, Mr. President, Your Honours. The victims participating in this case are represented today, myself, Orton Arenstig, and my colleague, James Maria. Thank you.
Good morning, Your Honours. Mr. Sang's team remains the same. Mr. Sang is present, and in addition to the team is one Mary Ann, who is a pro bono member of our team. Thank you.
Mr. President, Your Honours, good morning. Mr. Ruto, who is present in court, is represented by myself, Karim Khan, Mr. David Hooper of Queen's Counsel, Mr. Esafal of Counsel, Dato Shamla Alagendra. Your Honours, also I'm delighted to announce that Ms. Lee Laurie is now working as counsel. She's been admitted to the list. She's present in court, as well as our trial support assistant, Grace Sullivan, at the back, and then two pro bono interns, Clara Gerard Rodriguez, and also Mame Diara Bodge, MBODJ.
Thank you. From Nairobi.
Mr. President and Your Honours, Gregory Mutai for witness P604.
Thank you. I see. Okay, all right. Okay, thank you very much.
Mr. President, the registry's representative is in Nairobi too.
Thank you very much. I noticed that. Before we proceed with the rest of with the witnesses' testimony, I will need to read the further reasons for our ruling, partially postponing the testimony of witness 604. Before I do that, I wish to make one matter clear so that there is no confusion in the course of the litigation on postponement of the witness's testimony. References were made by both the chamber, of course, and counsel for the parties in the case. References made to the statements of witness 604, as well as the affidavit that he filed disavowing his statement to the prosecution. It needs to be stressed that those materials are not on the record of on the merits of this case. The statements of the witness of which we spoke and the affidavit were merely on the record for the procedure of litigating the postponement of his testimony. So if parties in the course of the testimony of the witness want to do anything with the statements and the affidavit, they will know how to go about it in the usual manner. Having said that, we will now read the further reasons for postponing the testimony of the witness partially. On the 2nd of September 2014, the Chamber partly granted Mr. Mutai's request to postpone the commencement of the testimony of witness 604, P604. We indicated on that occasion that we would in due course, provide fuller reasons for the postponement decision, we now do so. By way of procedural history, the following may be noted. Witness 604 was required to appear on the 1st of September 2014 to testify before the chamber by way of video link. This was pursuant to a summons to appear sent on the 1st of August 2014, issued on the basis of the decision of the chamber dated the 19th of June 2014. The record indicates that on the 11th of August 2014, the prosecution received an email from Mr. Mutai, representing the witness, with an affidavit in which witness 604 apparently recants the statement previously given to him, by him to the prosecution, and also announcing his withdrawal as a witness for the prosecution in the present case. That affidavit was accompanied by a letter signed by Mr. Mutai in which he announced himself as the lawyer for the witness and similarly communicated the disavowal apparently deposed in the affidavit. On the 26th of August 2014, Mr. Mutai sent an email to the prosecution seeking postponement of the testimony of witness 604 by 21 days in order to enable him take instructions from the witness. On the same day, the chamber, through the registry, having been informed of Mr. Mutai's request, directed that the witness was required to appear in accordance with the summons, but that Mr. Mutai may also appear on the date in question to make any preliminary submissions on behalf of the witness. The idea was to give not only Mr. Mutai, but also parties and participants in the case an opportunity to be heard on the matter should the request be pressed during the court session. On the 27th of August 2014, Mr. Mutai sent an email through which he sought reconsideration of the chamber's direction, submitting that he would require time to prepare. On the same day, the chamber again, by email, rejected the request communicated by Mr. Mutai by email, the request for reconsideration. On the 29th of August 2014, the registry transmitted to the chamber a further email from Mr. Mutai in which he repeated his request for a postponement of the witness's testimony, and in addition to the grounds previously raised, he submitted that the health of the witness and a possible instruction of senior counsel in the matter also warranted the requested postponement. A medical certificate was attached to the email from Mr. Mutai. The chamber reiterated by way of email transmitted by the registry that the witness was required to attend in accordance with the summons, but that it would hear preliminary submission from Mr. Mutai regarding the requested postponement before issuing a ruling. On the 1st of September 2014, the date scheduled for appearance of the witness, Witness 604, together with Mr. Mutai and a standby duty counsel appointed by the registry at the direction of the chamber, duly appeared before the chamber by way of video link. Having consulted with the witness, Mr. Mutai indicated that he was instructed to renew the request for postponement of the testimony. Mr. Mutai submitted 5 grounds for the requested postponement, namely: 1, the health status of the witness; 2, that he had not been provided with a copy of any statement of the witness and consequently was not in a position to advise and to guide the witness during his testimony. 3, the possible appointment of lead counsel to represent the witness in the matter and the need for the new lead counsel to take instructions. 4, time required for the witness to obtain M-Pesa and telephone records to support his testimony. And 5, that having had certain travel documents returned to him only that morning, the witness was not in a good state to testify, mental state to testify, believing that the actions had been taken to intimidate him. The prosecution, the defense team for Mr. Ruto and the counsel for victims opposed the request for a 21-day postponement, but there appeared to be common grounds that the testimony should not commence as scheduled on the 1st of September in the circumstances. And the prosecution and the victims' counsel considered that a 2 or 3 day postponement would be adequate. And Mr. Ruto's defense counsel argued that no more than 1 day's postponement was necessary. The defense team for Mr. Sang indicated that although they were ready to proceed, they were not opposed to the request, but suggested that a period of 14-day postponement may be sufficient. Also, on the 1st of September 2014, Mr. Mutai, following the day's proceedings, was provisionally included on the list of counsel and admitted to practice before this court. On the 1st and 2nd September 2014, the VWU reported directly to the chamber following a vulnerability assessment of the witness. The parties and participants do not have direct access to this report. In summary, it was advised that the witness had been interviewed by a VWU psychologist who formed the view that the witness's psychological condition is not such as would prevent him from testifying. The VWU also arranged for the witness's physical condition to be medically assessed by a physician. On the 2nd of September 2014, the chamber made a ruling granting in part the application for a postponement of the testimony of witness 604 and directed that the testimony would commence on Thursday, the 4th of September 2014 at 9:30 a.m., the Hague time, that is today, which time is 10:30 a.m. in Nairobi. The chamber explained that the purpose of granting the postponement of a further 2 days was in order to enable the VWU to complete its familiarization process with the witness, as well as to enable counsel to prepare. The chamber also indicated at that stage that fuller reasons would follow, which is what I'm doing now. Subsequently, on the 2nd of September 2014, the chamber was notified that the witness had indicated that he did not want to see the doctor arranged by VWU to perform a physical medical examination on the witness. The witness said that he was ready to testify without such medical examinations. Here now are the chamber's consideration of the 5 grounds raised by Mr. Mutai. The first ground argued by Mr. Mutai during the hearing of the 1st of September as warranting the request was poor health of the witness. Regarding the health status of the witness, the chamber notes that in neither the 21-day postponement request nor the request for reconsideration on that matter, as dated on the 26th and 27th of August 2014, respectively, was the held status of the witness raised. In addition, poor health of the witness was not mentioned at all, nor mentioned as a cause for concern in the witness's contact with the VWU between the 5th and the 27th of August 2014, nor was there any such indication in Mr. Mutai's communication of the 11th of August 2014, asserting the witness's apparent disavowal of his initial statement to the prosecution. It was only on the 28th of August 2014, following the Chamber's email rejection of Mr. Mutai's own email requests for postponement of the witness's appearance on the 1st of September 2014, that the VWU was first informed of such health concerns, and on Friday, the 29th of August 2014, in the renewed request for a 21-day postponement attaching a medical certificate. It was only then that this was brought to the attention of the Chamber by way of a record. It is noted that the medical certificate, which indicates that the witness had been under the care of a doctor for approximately the past month, does not directly address the question of fitness to testify, but advised that the witness should avoid stressful conditions. The Chamber wishes to emphasize that, as mentioned on the 1st of September 2014, we take very seriously our duty to protect the safety and well-being of witnesses. The Chamber has always made this a cardinal duty to manage the hearing of witness testimony in a manner which will minimize to the extent possible any related stress. There are, in addition, a number of practical measures designed to assist witnesses, including, in particular, the witness familiarization procedures conducted by the VWU. The Chamber was also guided in this matter by the independent assessment provided by the VWU, which addressed the specific question of the witness's fitness to testify. On this basis, the Chamber is satisfied that the health status of the witness is not such as would prevent him from testifying in this case. The witness's subsequent indication of readiness to testify and willingness to attend, the unwillingness, that is, lack of willingness to attend the additionally scheduled medical appointment also confirms this assessment. The Chamber will separately consider any specific recommendations of the VWU for special measures to facilitate the testimony of the witness. It is also noted in that regard that the prosecution's request for in-court protective measures for this witness is outstanding, and that the Chamber will also rule on that request once it has heard submissions from each of the parties. The Chamber turns now to the second ground relating to the provision of the witness's statements to counsel. It is noted, with effect from the 1st of September 2014, that Mr. Mutai was provisionally included on the list of counsel admitted to practice before the court and pursuant to the direction of the Chamber, has since been provided with access to the witness's statements. Noting the scope of representation outlined in the Chamber's directions given orally on the 2nd of September, the Chamber did not consider that access to the statements on the part of counsel constituted a prerequisite justifying a postponement, in particular of the magnitude of postponement requested. Mr. Mutai's third ground regarding the possible appointment of lead counsel to represent the witness in this matter was ruled upon by the Chamber on the 2nd of September 2014. In respect of the fourth submission that time is needed for the witness to obtain certain telephone and M-Pesa records, the Chamber considers that the necessity of any such records can be considered as appropriate during the course of the testimony. As noted in the oral submissions, the witness may put in motion an application for access to such records now in order for them to be available as soon as possible when needed. However, the Chamber will only consider this matter further should it become relevant during the course of the witness's testimony. In any event, the Chamber does not consider that it warrants delay in the commencement of the testimony to the extent requested by Mr. Mutai. Finally, in respect of Mr. Mutai's submission regarding the witness's travel documents, the Chamber notes that clarification of the circumstances of that matter was provided during the course of the oral submissions. The Chamber did not consider that it provided any impediment to the commencement of the testimony. That is those are the reasons for the partial grant of the request to postpone. Now we will take submissions on protective measures requested by the prosecution. Ordinarily, these submissions are done in closed session, so we will go into private session. We'll go into private session for the submissions to be taken.